Want to be sure you are getting the most out of your retirement? For all the years of your retirement? That's the primary goal of More Living with Jim Brogan and our Dollars and Cents segment, where we provide you with an important financial tip that will help positively impact the quality of your life in retirement. And now, here's Jim with this week's Dollars and Cents tip.
Understanding the power of attorney document and what it does and what it does not do. First off, there are two primary main power of attorney documents. There's the medical power of attorney, which is for someone to make your medical decisions when you cannot. And then there's the financial power of attorney, which is for someone to pay your bills and administer your affairs when you cannot. Many people are not aware, like on a financial power of attorney, there are some accounts you have that are in your name. If you have retirement accounts, IRA, 401k, it's an individual retirement account. It's just in your name. You may think that if something happens to you and you're temporarily incapacitated, your spouse can act for you on that, not without the proper legal documentation, because your spouse is not on that. They're not a co-owner of an IRA. And with all the privacy laws and things, it can get hairy. Same things can happen with the medical power of attorney. The main thing I want to cover is that there are two main kinds of powers of attorney. Not that there aren't more, but there's two main ones. One is what's called a durable power of attorney, and the other is what's called a springing power of attorney. Let's start with the durable power of attorney. If I've named my wife as my durable financial power of attorney, she is my power of attorney, both now and in the future. The word durable actually means the power of attorney is durable upon my incapacity. In other words, she can make decisions for me and pay my bills when I'm incapacitated, but she can do that now too. So if I name her as my financial power of attorney, she could actually go clean out my bank account. Now, we're a first marriage. I'm not at all worried about that. The other type of power of attorney is a springing power of attorney. A springing power of attorney springs to life upon your incapacity. So if I named her my springing power of attorney, then she has to show the fact that I cannot act for myself. And if I want, I can have my day in court. Now, you can do this with a medical or a financial power of attorney. And when I tell folks about the differences, their initial reaction is, well, why wouldn't everybody do a springing power of attorney? Well, there's challenges with that too. My father had a springing medical power of attorney. And so he had to be proven incompetent or having lack of capacity for us to make his decisions. And we went through a phase where he didn't want to give that up. And for us to do that, he was a former lawyer in his working career. He would have had his day in court. He would have been able to challenge us taking over his medical decisions. And he would have done it. And he could have cleaned himself up, gotten himself into court at first thing in the morning. He had vascular dementia. He was also dealing with some ongoing alcohol issues. And he could have gotten in front of a judge, I think, and cleaned himself up and made a compelling case. But the hardest thing for us is we would have had to sit there and tell the judge, my dad is incapable. He's incompetent now to make his own medical decisions. And that can be very, very difficult. It can even be difficult with a spouse. So what I typically see is with first marriages, people do name their spouses their regular power of attorney. They don't do a springing power of attorney. Where we see springing powers of attorney more frequently is when it's a second marriage, maybe you have a blended family, or maybe you've named your child or your children in a specific order. You may not want them to just be able to act. You may want, some sort of an event to trigger that. But that can get challenging too when you start paying bills and doing things like that. So the bottom line is when you work with an attorney to draft these documents, and I'm not an attorney, but I think it's important that they either educate you on these different options and what they mean so you can make an informed and prudent decision, or they ask you the right types of questions so that they can make the proper recommendation. But if you go, the only way that's going to happen, either way though, is if the attorney spends time getting to know you and your family needs. A 10-minute interview or even a 30-minute interview with an attorney is probably not going to be enough for them to truly understand your needs to make the appropriate recommendations. So when you're working with an attorney, work with someone who is thorough, complete, and really understands you and takes the time to get to know your needs.
That's our Dollars and Cents segment for this week. You can find this week's Dollars and Cents segment and others by visiting BroganFinancial.com.